I am so disappointed in Diddy's attorneys in the letters that they presented in the court, trying to convince the court of why Diddy should be let out of jail. And the biggest reason why I'm disappointed in them is because they are using the black card. The black card. Y'all are doing this to me because I'm black. Y'all are not letting me out because I'm black. Y'all let Trump out and let Trump talk to everybody because he's not black. You know what? Pulling the race card for me, calling the prosecution racist for me, it lets me know that you do not have a strong argument. And to support my contention on this, we're going to review Diddy's letter trying to explain why he should be let out of jail. And in my opinion, his defense team just doesn't have a basis for it, which results in saying that it is okay for Diddy to go out there and say the prosecution is doing this to me because I am black. Now, do I agree that he has been arrested and he's being charged by the prosecution because he's black? No, I do not. I do not, as a black person, I do not, as a black person, I do not believe that these cases are going forward against him because he's black. There's been several cases, all kinds of races, all kind of famous people of different backgrounds, including the Jefferies case, which he again cites to and accusing, and then Trump case. I don't think Trump case had similar allegations, but all of these people have been going on trial, being convicted, and he wants to say you guys are being unfair to me because I'm black. I don't like that. I don't like that. But Diddy wants us to know that he's just like Trump. I can tell you one thing, Diddy, you're not like Trump because Trump is not black. And that's one of the allegations that you're using that you feel like it's fair for you to say. So today we are going to be going over why the state or the government believes that Diddy case is different than the Jefferies case, that Abercrombie and Finch one, where he was being accused of trafficking men and also threatening them with their security company. And then we're going to get into Diddy's reasoning onto why what kind of communications he's been into that would result in basically what communications has he done where the court asks for more information. And then we're going to get into the state's reasoning of pointing out what actions has Diddy done in order to not be released because he's already violated the communications in the jail. Now, I'm gonna be honest with you, we probably won't read a lot of Diddy's document because it absolutely makes no sense. It just cites a bunch of cases. And it doesn't really tie anything together. I was confused reading it. I'm sure the judge is going to be confused reading it. And I know YouTube is going to be confused with me reading it. So I'm not going to spend an hour trying to get through that document because it makes absolutely no sense. They don't tie anything together. And I think they just nailed the nail in the coffin for keeping Diddy in jail. So let's go ahead and jump into why the state thinks that the Jeffrey case that Diddy previously cited is different than his current case, although they are facing similar allegations. So let's have Bossy B bring us in. Go ahead. Y'all know we are live. If you have comments, make sure you're dropping them in the chat section and we will get to it at the end of the stream. Let's have Bossy B bring. All right, y'all. So if you were watching the channel last week, there was a lot of Diddy streams. We had a lot of Diddy streams. We did not get a verdict on whether Diddy is going to be released from jail. Still, we didn't get it on Friday. We didn't get it today. But what we did get today was letters from both of the government and from Diddy as to why he should get out of jail or why he should stay in jail. But before we get into that, the state actually addresses Diddy saying, well, you guys let Jefferies out on ankle monitoring and a $10 million bail. Why are you guys not letting me out? The state says, I got something for you. I can tell you exactly why we are not letting you out and why we are letting Jefferies out. So let's see what the prosecution says, what the government says. I think it's still prosecution, right? What they say as to why you are different than Jefferies. And according to Diddy, the only difference between him and Jefferies is that he's black. No, that is not the only difference. The state actually comes with the USA actually comes with good reasonings on why he is different than Jefferies. So first, Diddy, you are different from Jefferies because the nature and circumstances of the offenses are substantially different. While the Jefferies case, which spans from 2008 to 2015, alleges the use of force, fraud, and coercion to engage in to engage men in non-consensual sex. There are no allegations that Jefferies committed non-trafficking related violent acts or that he used firearms during the charge period. The indictment against Combs alleges both. With respect to the charged offenses, Jeffrey does not include a racketeering offense. By contrast, Combs is charged with leading a racketeering enterprise that engaged in persistent pattern of racketeering activity from 2008 to 2014. So not only are your crimes a little bit more serious, but you're also being accused of doing it for almost 10 years longer than what they're being accused of in the Jefferies case. So let's go on. From 2008 through 2024, that included repeated acts of violence by Combs and his co-conspirators, including multiple acts involving kidnapping, arson, and forced labor. Further, as detailed in the indictment, Combs protected and promoted his role in the enterprise through violence, use of firearms, threats, coercion, and verbal, emotional, physical, and sexual abuse. As recently as March 2024, firearms and ammunition, including 3 AR-15s with the face serial numbers, were recovered from Combs' residence. And did y'all forget about that? Remember when they seized Diddy's house and he had guns with scratched off serial numbers on it? Yeah, you can't do that. And then you're blowing up people's cars allegedly, and you have all of these violent acts being alleged against you, while we'll get into why Jefferies doesn't seem as intimidating. Yes, he induced men to engage in sexual acts and potentially threatened them with security companies to make sure that they don't go out and talk. However, Diddy has all of these other violent crimes outside of the sex trafficking allegations. And even with the threats that Jeffrey was doing, the prosecution is basically saying they're not using firearms and things like that in order to threaten people. So the second reason why the state believes that Diddy is different from Jeffries and to stop whining is because the defense criminal conduct, including acts of obstruction, has persisted through present. While Jeffries allegedly also engaged in efforts to conceal criminal activity, including through the use of surveillance and threats of litigation to ensure victim silence, that alleged conduct ended in 2015. Here, however, the conduct charged against Combs extends through 2024. And even since being charged, Combs has continued his obstructive conduct, included by repeatedly flouting the orders of this court and the rules and regulations of the BOP. For all the reasons cited in the government's opposition, it strains credulity. Why can't I say that word? Credulity. We're going to go with that. To believe that Combs will stop engaging in criminal conduct and abide by conditions of release. He hasn't even followed the rules in jail. Why would we believe that he's going to follow the rules out of jail is essentially what they're saying there. And lastly, the history and characteristics of the two defendants are significantly different. If you ask Diddy, it's because Jeffries is white and he's black, but that is not what the prosecution points out in this. They say that Jeffries is 80 years old with no criminal history. Combs is decades younger. Further, he has been arrested and investigated multiple times for crimes of violence and obstruction, and as described above, has repeatedly violated the BOP regulations and the very same gag order he demanded in the court. And so for those reasons, Jeffrey is different than Diddy, and it's not because he's black and Jeffries is white. So sorry, Diddy, your allegations thinking that the court is treating you different for, just being Diddy, that's not happening here. Like, you're literally being accused of very dangerous crimes. Now, while I'm not saying that Jeffries is an angel, he also, like they said, is 80 years old. He might be an active 80-year-old. I don't know him like that. But he also doesn't have all of the things going against him as you have going against you. For one, you have a criminal history, allegedly. Now, have anyone been able to put Diddy in jail? No, but still, you have those allegations against you, and a lot more people coming forward saying that you are also doing these violent things to them. So that is why the state or the prosecution or the USA, whatever you want to call them, why they think that the Jefferies bail condition, which I said at the beginning of the stream, is $10 million and an ankle monitor. They thought that was sufficient for Jefferies and his co-defendant, but they don't think that money and watching Diddy is going to be sufficient because he breaks all of these rules constantly and he's accused of violent crimes and all of the above, right? And with the charge being sex trafficking, as it is in the Jefferies case, there's a presumption that we won't be able to do anything to stop you from being bad, essentially, and to make sure that you're going to show up to court. But basically, Jefferies have these mitigating factors as to why he's able to be released and why Diddy is not able to be released. Why Diddy doesn't understand that, I absolutely do not know. I don't know. You're continuing to break rules, and we'll get into it. Diddy continued to break rules. He told the court, I'm not doing this anymore. And then he turns around and do it like yesterday. So let's go ahead and jump into the defense's letter. Y'all, I'm really not that prepared to go through it, but we're going to try. We are going to try. And y'all, don't forget that this is a live stream. So if you have comments, go ahead and drop them in the chat. We're going to talk about it at the end of the live stream. If you're watching on the replay, go ahead and drop it in the comments. And if you haven't already, please do hit the like button. I don't know. Let's make the like goal for the stream 30 likes. So do your part, hit the like button. Let's get into Diddy's kind of addressing the court and what they requested from them. So if you guys recall, last Friday, the court decided not to make a decision on whether they were going to release Diddy on bail, but instead instructed both the government and Diddy's counsel to basically brief the court on what kind of conduct Diddy has been engaged in and how is it a violation of the current rules in place. They also wanted some more information on how any of these bail conditions or any of the lockup conditions would affect Diddy's First Amendment right and his Sixth Amendment right. His right to counsel is the Sixth Amendment right, and then his right to freedom of speech, which is his First Amendment right. And so what I will say about the defense counsel's letter is nothing. I got nothing from the letter. I don't know what they were trying to explain. They were like, it's a violation of his First Amendment right. And I'm like, okay, yeah, tell me why. Tell me why it's a violation of his First Amendment right. He should be able to talk to the press. Okay, I get that, but he's not supposed to do it through people and, add contacts by three-waying people and confronting witnesses and all of those things. So please explain to me how that's not a violation. He absolutely doesn't address the violations that he's already committed, which we've gone over last week. He's already used the phone to call on three-way when he's not supposed to. He's also used other prisoners, other inmates' code so that it's harder for the government to track what calls are going out from Diddy and what calls are going out from that actual inmate. They didn't address any of that. And then he's also using this messaging app, which he said he didn't know he could use, but then he did know he can use it, and that he's not using it anymore as of November 16th. But lo and behold, he used it yesterday. And not only did he use it yesterday, he used it through a third party or another inmate. So he didn't even use his code in order to use this messaging service. So he wants to tell the court, hey, court, look at me. I'm doing really good. I didn't know that I couldn't use this third party messaging app. But look, I'm not using it. I'm not using it under my code, but I'm going to use it over on bro over here's code. Like, no, you can't do that and say, I'm good, because you're not going to catch me. It's literally his argument and how he's trying to go forward with this. Now, I don't think that the argument was that he couldn't use the messaging service. I think the argument was that he was using the messaging service to contact people that were not on his contact list. I still haven't gone back through the documents to try to find it because it's a lot of documents and a lot of words, and I don't got time for that, okay? But that's my interpretation of the argument, not that he couldn't use it at all. But the fact that he went and used it under someone else's PAC number, their prisoner or something, phone contact code, whatever it's called. The fact that he went and used it under someone else's code and then came to the court and said, oh, well, I don't use it anymore, that just kind of shows that he is being deceptive. So let me go ahead and try to get into this letter. I'm telling y'all, I don't even know where to jump around in this, to tell y'all the truth. I'm almost feeling like I should just skip the letter because, like I said, I got nothing from it. So I can't give y'all nothing from it, okay? But otherwise, anyways, we're going to go ahead and get into it. I just rambled for so long, but let's go ahead and check out at least the start of what it says. He says, the defense counsel says, defendant Sean Combs respectfully submits this letter in response to the court's request at the November 22nd, 2024 hearing for further briefing on the contours of the types of communication that Mr. Combs is able to engage in, consistent with the court's order and Rule 23.1 and the First and Sixth Amendment. When I read that sentence, I thought they were going to give me details, give me the juice. No, they don't. For months and months, and here we go in the attacking of the government. And for months and months, government agents, plaintiffs' attorneys, and others with questionable motives have been polluting the airwaves with false and outrageous claims about Mr. Combs. This nonstop drumbeat of negative publicity has destroyed his reputation and will make it virtually impossible for him to receive a fair trial. Mr. Combs is not required to sit idly by and acquiesce to all of this. He has a right to a fair trial and a constitutional right to speak out on his own behalf. No one's saying that he doesn't have the right to speak out on his own behalf. The issue with him speaking out on his own behalf is he's doing it through channels that he's not permitted to do it to, through, i.e., calling his brother, calling his sister, and telling them, hey, tell this to the press, or tell this witness to say this to the press, or let me pay you to go ahead and say this to the press. You cannot do that, okay? You just can't do that part of it. Speak to the media, but do it through the proper communication channels. Speak to the witnesses, but have your attorney present. Have your attorney being the one that's speaking to the witnesses so that you can make sure that you're not doing anything wrong, because attorneys have rules that we have to follow and their license are on the line. You, on the other hand, your life is on the line. So you want to make sure that your attorneys are doing the job the best possible way, rather than you taking it into your own hands, especially when all the communication that you have done to people have been construed to be obstruction. So what would you want to do? Avoid any obstruction. So no one's saying that you can't talk to the press. What we're saying is the way you're doing it is not permitted by the law. So don't know why the attorney didn't focus on that, because I don't think they have a leg to stand on here. He has a right to a fair trial and a constitutional right to speak out on his own behalf. The government's argument that asking his children to post birthday wishes on Instagram that he is not entitled to publicly express his opinion, that this prosecution is racially motivated, are quite simply an unconstitutional effort to silence him. And I don't even think the prosecution pointed that out. They pointed out the post and they decided to hone in on the racial motivation, I believe, because they know that it's a sensitive topic. What I remember reading out of the prosecution is that Diddy is putting these messages out to specifically taint the jury pool. They don't really address that. In fact, they kind of embrace it. They say he is able to influence the jury pool because all of this stuff that has already come out about Diddy and his reputation, that's tainting the jury pool. So I'm just going to re-taint the jury pool to be in my favor. And then they cite cases and flip the case to basically support his position that he should be able to taint the jury pool. Like, he's not even saying, no, I'm not doing that. You guys got it all wrong. I'm not tainting the jury pool. That's not my intention. No, my guy is like, I am allowed to talk to the jurors, and to avoid them being influenced, y'all should do a better job on voir dire when we go to trial. Like, absolutely not. Who are these attorneys? I will not be surprised when Diddy is not let out on bail, and y'all, hopefully I'm right on that. When he's not let out on bail, I can guarantee you that he's probably going to fire this attorney and try to find someone who's going to fight harder for him. Now, one thing that litigants don't understand is that it's not that the attorney is not fighting hard for you. It's that your position is not good. Think about Sarah Boone's. We covered that trial. Sarah Boone's position was not good. So there was really nothing her attorney could do to fight for her. Their arguments here, there's really nothing they can do but confuse us in their letter. But there's really nothing to fight for. You're breaking the rules. You're breaking the rules, Diddy. I don't know how your attorneys are going to help you here. Mr. Combs sought only to stop a wave of publicity he perceived as prejudicing potential jurors. What did I just say? He doesn't even deny it. He doesn't even deny it. He goes straight in and goes, no, Mr. Combs sought only to stop a wave of publicity he perceives as prejudicing potential jurors and injuring his reputation in the community. And they cite a case. He has a right to undo his perceived prejudicing of the jury pool. No. And so I'm going to read through this, but the state also cites this case, and they basically explain it a lot better than the defense is. They're basically citing this rule in order to, as we can see, there's a lot of ellipses in here. So we're missing some information here, right? His communications directly at the public are protected speech under the First Amendment and cannot justify denying bail or indeed preventing him from engaging in constitutionally protected public relation effort, as long as they comport with the carefully tailored legal limits imposed by the controlling authorities described below. Now, again, I don't think they ever explain anything to us, but let's go ahead and try to jump around in this. Mr. Combs' communication regarding potential public statements and social media posts constitute protected speech by the First Amendment. Under the Trump case, we wants to cite Trump because he's just like Trump, so let's see. Assumed without deciding the most demanding scrutiny applies to the pretrial speech restrictions on criminal defendants, and that only significant and imminent threat to the administration of the criminal justice will support restricting a defendant's speech. The court considered but rejected application of a less exacting substantial likelihood material prejudice standard articulated in Gentile, which considered a professional disciplinary sanction. So this goes on to say, in Trump's case, they're using the strongest standard to determine whether his speech is protected. We can't silence Diddy because he has to make sure that there is a fair trial, while the Gentile case actually had a lower standard, which was the substantial likelihood of prejudicing the jury pool. So again, he doesn't really explain how. Okay, I guess this is what he says to explain it. Accordingly, the court should apply Trump's heightened standard, which he also forgets about his gag order that he asked to be put in place. And so he's asking to do the higher standard. So yes, he talked to the public, but is what he said to the highest standard gonna violate the right to a fair trial versus the lower standard of substantial likelihood of violating, tainting the jury pool? And then they go on to skip into the government has a heavy burden to basically establish that they're not violating Diddy's rights to his First Amendment, his right to public speech, right, about his case. Let me see here. Where did I want to go here? Okay, the party seeking to justify a speech restriction bears a heavy burden of demonstrating in advance of trial that without prior restraint of a fair trial will be denied. The record must show the specific words have an extraordinary power to undermine or destroy the efficacy of the criminal justice system. It must be established the imminence and magnitude as well as the likelihood of harm in the court's core duty to ensure a fair and orderly conduct of a criminal trial in its truth-finding functions. In making the determination, the court should consider such factors as the speech's phrasing, timing, setting, and meaning. And so he's saying, y'all already ruined my reputation. I should be able to try to correct my reputation, but they don't ever tie that together. The court should consider the forms of media at issue and their circulation as mere presence of an extrajudicial comment, and some forms of the media does not by itself establish the potential of prejudice of the jury veneer. Let me see here. And then he doesn't go on to explain how this relates to him. Like, y'all, I'm telling y'all, I'm gonna have a hard time getting through this because they don't tie anything together. The speech at issue does not risk undermining a fair trial. And so the cited examples do not even remotely implicate the types of possibly prejudicial speech that the courts have previously considered. This is not speech about witness testimony or cooperation that imperils the availability, content, or integrity of the witness testimony. Nor does the speech target known or reasonably foreseeable witnesses concerning their potential participation in the case. And so the statements, where is it? I forgot where it is. I'm sorry, y'all. I forgot where it is. The statements that they're referring to is Diddy basically saying that the prosecution is racially biased against him because he's black, right? Because that's what race he is, right? And that he's reaching out to have his, well, no, this is not what they're using. The state comes and tells them the real reason why they have a problem with his statement. So his is, here we go. There it is. I forgot where it was, but I found it. Mr. Combs' speech falls on the opposite side of the line and is clearly protected. Anticipated speech about a revolutionary or about a racist prosecution involves thoughts that the prosecution is politically motivated and that he is innocent of the charges against him, for the core speech protected. They're citing Trump again. Indeed, criticizing the Department of Justice and the prosecutors is not prescribed. is not prescribed. You criticize the prosecutors. You're calling them racially biased and politically motivated. Criticism of the government is very centered to the constitutionally protected free discussion. Mr. Combs' anticipated words were directed at the public officials and their conduct in office. There is no question that the speech critical of the exercise of the state's power lies at the very center of the First Amendment. So he is trying to basically explain his side of the story. As for Mr. Combs' children's birthday wishes, that message was entirely innocuous. It could not possibly produce an interference that is material, nor was the message made with knowledge that such interference is highly likely to result or made intending to delay or obstruct the justice. It is no response to cite Mr. Combs' subjective hope that his birthday message would reach the public, including potential jurors. Okay, so that's what it was. He made a statement that he wanted his birthday message, basically his kids singing on a video and saying how much they miss their dad and that he's not a bad person and that we got it all wrong. He wanted it to reach the masses. He first made them post it on their own channels. And then he was like, this is not getting enough reach. Let me go ahead and post it on my channel. And then he talked about it afterwards saying this got so much reach. We did a good job or whatever it may be. Basically indicating that he wants to reach more people that could potentially be a part of the jury pool and that could potentially help his case moving forward. So let's go on to what he got to say. It is no response to cite Mr. Combs' subjective hope that his birthday message would reach the public, including potential jurors. Mr. Combs' reputation is drowning in a sea of negative publicity prompted by the government's prosecution here, as well as dozens of civil suits, and he is free to defend himself in the court of public opinion. Now, the court of public opinion. Now, remember, Diddy is the one that asked for this protective order. He don't want the government talking. You don't want your defense counsel talking. And the court also ordered you not to talk. So you can't then go and say, well, that only applies to the prosecution. I don't want them to say bad things about me. I don't want my counsel to say bad things about me, but I'm going to say bad things about them, even though I am also included in the order. You're the one that wanted the gag order. And Diddy wanted a more restrictive gag order than the one that's even in place. Okay, so let's see. Which is all the statements cited by the government's evidence. Indeed, as noted, Mr. Combs' reply, a core assumption underlying Gentile in the First Amendment is that the press comment is sometimes necessary to protect the rights of the defendant and defend his reputation. So he feels like he's defending his reputation by claiming that the state got it all wrong and that they're racist. Now, I don't know how that helps him, but that is the argument that he is arguing. He's saying that less restrictive alternatives to detention adequately mitigate any risk, even if the speech at issue comes close to the line, which again, it doesn't. Before deeming it impermissible and punishing Mr. Combs, the court must consider less restrictive alternatives. He basically cites that in voir dire, they'll be able to ask questions in order to get rid of anyone that has been tainted by whatever he is saying to the public. They go on to talk about the government stated rule is overly broad and vague. They just cite a bunch of cases and say they don't think that the state's authority is correct. And when asked on the spot, they couldn't give the court a specific citation when the court asked, what does obstruction mean? Mr. Combs' other conduct is protected by the Sixth Amendment. He again goes on to talk about how he is able to contact witnesses in order to prepare for his defense and that he's not actually contacting victims directly. So again, he doesn't deny that he's doing these things. He basically just says, my conduct is protected. For your conduct to continue to be protected, let your attorneys do it. Stop doing it yourself. You hired attorneys for a reason. Otherwise, get a public defender. And again, they're still supposed to defend your position, but maybe they may not listen to you as much because of all the cases that they have. But you should not be going out here and contacting jurors, not jurors. You shouldn't be going out there contacting the witnesses for yourself. You should tell your attorney, hey, this person is a witness. Can you contact them? You are in jail and you have been accused of obstructing justice. So how about you try to take the proper route and go through your attorney. And then you won't be accused of doing these things, calling people from numbers you're not supposed to be calling them from. You might as well have a burner phone at that point if you're going to be using other inmates collect call time, right? You're paying people off. You're basically demonstrating to the court that you're going to continue to pay people off to get what you want in the case. So again, like I said, it's a bunch of citation. As y'all can see, it was hard for me to get through it. But what I will say is that the prosecution, the U.S. government, they eat the defense up. Now, they didn't already told us why Diddy is different from Jefferies. Now they're going to go into why Diddy, what conduct. As you can see, this whole letter, we barely address any of Diddy's conduct. It was all case law and this, and he should be held to the same standard of this person. A bunch of word salad, a bunch of citation salad, not tying anything together to support Diddy's position. And if y'all don't believe me, you can read it yourself. I was confused reading this, okay? It's one thing to cite cases. That's good. We need the citations. We need the support. We need the authority. But to not tie it together, for me, a lawyer, I couldn't tie it together. I don't think anyone else will be able to tie it together. And I definitely don't think the judge is going to tie it together. Now, the state's position is clear. It's concise. They explain exactly what they mean. Last week, I was on the defense side for something because they was coming with that creative writing, right? This time, I'm not on the defense side. I'm on the state's. I'm judging the lawyering. The lawyering on the state side this time was substantially better than the defense. They have clearer points, which is going to make it more likely that the judge is going to rule in their favor, so long as they're accurately citing the case law and comparing it to defendant or to Diddy as to why he needs to stay in jail. So he said he was talking to, he's protected by the Sixth Amendment, the First Amendment, and he can do whatever he wants. It's basically what he's telling the court. I can do whatever I want. So let's go ahead and jump into the state's position regarding everything. Okay. Like I said, the state's response, the state's letter to what the court asked for is substantially better than the defense's response. And do you know why their answer is substantially better? It's because they actually asked the question. Just for a reminder for the people that are coming in now, the court last week asked both the defense and the prosecution to answer what conduct has the defendant been doing since he's been in jail that is a violation of the BOP rules. What kind of communication is he allowed? What has he been doing? And if we are to go forward, what kind of communication would be permissible moving forward? Defense does not answer the question. They just basically says he can reach out to whoever he wants because he's protected by the Constitution of the United States. Okay. I don't agree. I didn't understand it. Their argument was not concise. The state, on the other hand, comes in and tells us exactly what Diddy has been doing and exactly what past conduct he has that would support holding him in jail, and exactly what he has been doing and what rules he has been violating within the detention center, and the fact that he is asking for private security that he's going to pay when there is evidence and there is going to be testimony that he has already manipulated his own private security in the past. What makes us think he's not going to do it again? And most importantly, he's been violating all the rules in jail. Why would we believe that he's going to not violate rules in his own house? And his own attorneys are making it seem like what he is doing is not that big of a deal. So why would they then monitor him when he's at his house? And like, do y'all not have other clients? Because how y'all gonna monitor this grown man with a yacht and an airplane? How y'all gonna monitor him and y'all can't even get him to stop using other people's phone to message people while in jail? And then you gonna say, oh, it's his First Amendment right. It's his Sixth Amendment right. You letting him do whatever he wants. Who's to say what he's doing outside of the jail won't be his First Amendment right and his Sixth Amendment right according to you? Again, y'all didn't tie nothing together, so I still don't know what his First and Sixth Amendment rights are. in context to the facts of this case, but that's your argument nonetheless. Let's see what the state has to say. I know I've been rambling tonight. Okay. The government respectfully submits this letter in furtherance of opposition of the defendant's renewed application for bail and the following the November 22nd, 2024 bail hearing in the above captioned matter. At the hearing, the court requested the parties address whether the defendant's conduct constituted obstruction for the purpose of the bail reform. Did the defense answer that question? No. In addition, the court ordered the parties to address whether the defendant's conduct violated the court's October 25th, 2024 order and the local criminal rule 23.1 and what communications the defendant would properly be able to engage in on a prospective basis. Did the defense answer that? No. For the reasons set forth below, defendant's conduct both past and present constitutes obstruction, and his recent efforts to influence the jury pool are in violation of the local criminal rule 23.1. Did he even deny he was trying to taint the jury pool? No. He said it was part of his Sixth Amendment right, his First Amendment right to post that message. Yeah. From behind bars, posting messages. Okay. And in contempt of any very order, incorporated the rule that the defendant demanded. The defendant's argument that any of this conduct is protected by First Amendment are similarly baseless. You forgot the Sixth Amendment. He also thinks he's protected by that as well. Moreover, as detailed in the prior hearings and briefly addressed below, the defendant's history of obstructive conduct is part and parcel to his decades-long pattern of violence, which must be considered along with his obstructive conduct to fully assess his dangerousness under the Bail Reform Act. A holistic view of his obstructive and violent conduct that is still happening presently, makes clear that there is no way to rebut the applicable presumption of detention in this case. The bail package presented by the defendant does not come close to ensuring the safety of the community, including from the defendant's ongoing efforts to obstruct this case, nor does it adequately protect from risk of flight. For all of these reasons, the defendant's renewed application must be denied. And so they go on to talk about obstruction and how there's a broad definition. Remember, the defense's argument is that the state wants it to be broad, but it's not as broad as the state thinks it is. The state goes on, or the prosecution goes on to cite cases that it is broad. Let's see. They go on to explain that there's some cases. The case that they cited found that a defendant threat to a family member, which resulted in the revocation of defendant's bond, constituted obstruction of justice because the defendant willfully impeded the administration of justice. Let's go ahead and jump into what Diddy has been doing. Okay. So obstruction is broad. Anything that basically interferes with the possibility of a fair trial is what the obstruction rule is, according to the government. Here, Diddy's action fall easily within the definition of obstruction. Indeed, there is significant evidence that the defendant has engaged in multiple acts of obstructions during the time period relevant to the charged offenses and poses a serious risk of continuing obstruction as set forth below. These acts include multiple acts he took in effort to stave off the instant criminal charges, as well as acts he continued to undertake even after the indictment was returned in order to dissipate the potential evidence against him. So what has Diddy been doing? He is charged with racketeering conspiracy offense in count 1. So he's already being accused of obstruction. Oh, that's one thing that I forgot to mention because I kind of skipped over that first paragraph. So the fact that he's being accused of sex trafficking, a violent crime, that creates a presumption that no rules that they can put in place would protect the community. And in addition to that, he's already being accused of obstruction, which makes it more likely that he's going to continue the obstruction outside of jail, which support the reason of holding him in with no bail. So they go ahead and list the fact that he is being accused of racketeering conspiracy. He's already using people to threaten other people, allegedly, right? In 2016, defendant bribed security officers with $1,000 in cash to destroy evidence of a brutal assault on a female victim while they were in Los Angeles hotel for a freak-off. See the November 22nd, 2024. That was Cassie, who is the person involved in this case. He also encouraged his intermediaries, so maybe a security staff, maybe an employee, to also offer these these hotel staff $100,000 in order to get rid of the tape. Now, I thought it was $50,000, but the state is now saying that it is $100,000 that was offered to get rid of that tape, which they didn't do a good job in getting rid of that tape. Third thing that Diddy has done. After a victim filed a civil lawsuit in 2023 alleging, amongst other things, that the victims participated in freak-offs was not consensual, the defendant made multiple efforts to interfere with victims and witnesses by feeding those individual false narratives regarding the defendant's criminal conduct. For instance, the defendant caused intermediaries, former or current security staff, which he's asking to hire his own security staff, wink, wink, that's a little bit suspicious, to repeatedly call a former employee who had witnessed firsthand the defendant's abuse of the victim. The intermediates told employee one in sum and substance that what she had observed was a normal relationship. Around the same time, and as highlighted in the prior hearing, the defendant recorded 2 phone calls with a different victim in which the defendant attempted to feed victim 2 a false narrative regarding victims 2 involvement in freak-offs, namely basically trying to convince them that it was consensual. What else has Diddy done? The defendant has evidently deleted messages between himself and 2 key witnesses, including a grand jury witness and victim 2 in the criminal case. One of these witnesses is witness 1, a male commercial sex worker who participated in freak-offs and received a grand jury subpoena. Ooh, they gave us more information in this letter. So one person that testified was a male commercial sex worker who testified as the grand jury. We talked about that in the last live stream where they were like, oh, after this person was on the grand jury, Diddy contacted them. Then his lawyers contacted them knowing that he was represented by an attorney. Oh, this is getting juicy. I feel like each filing, they let a little bit more information slip out. And so they did right there. So now we know one of the grand jury witnesses was a male sex worker. So there we have it there. After defense counsel represented unequivocally at the prior bail hearing before Judge Carter that defendant would not reach out to a jury witness, it became clear that defendant had done just that. And remember, Diddy was represented by these attorneys prior to the indictment being brought, prior to the grand jury indictment. So they are saying they would not have let him do it, yet he's still doing it and he's under their advisement, right? And they don't know about it. There's no way they're going to be able to monitor him unless they move in with him and don't let allegedly him drug you. So they're claiming they're going to be able to control him unless they don't have any other clients. And no, you're not going to be able to control a grown man. I'm sorry. They're just not going to be able to do that. But anyways, they were already representing him. After the defense counsel represented unequivocally, why can I not say that today? Unequivocally at the prior bail hearing before Judge Carter that defendant would not reach out to a grand jury witness, it became clear that defendant had done just that. Phone records and electronic evidence shows that defendants contacted witness 1 repeatedly leading up to and after his appearance in the grand jury, and then the defendant apparently deleted the messages from his phone, basically trying to hide evidence. There were further communications and there were text messages through the entire period, including to August 24th, that were deleted. So he was trying to manipulate them all the way up until about a month before he was actually arrested. In the lead up to his arrest, the defendant similarly appeared to have deleted messages with victim 2, including related to significant monetary payment he was continuing to provide to victim 2. So he was basically paying victim 2 off to keep their story consistent with what Diddy needed to testify in order to get off on this charge, in order to not be convicted on this charge. So we are on page 4 of the state's letter. We have a clearer picture already, concise, in order, reminding the judge of all the bad things Diddy has done. On page 4, like, defense, are y'all really trying to get Diddy out, or y'all not trying to get him out? I not understand. There's no explaining around what he has done. There's no explaining around that. So all you can do is cite random cases and hope that the court believes they apply to your defendant. But you need facts in there to explain. The court specifically asked, what has Diddy been doing that he's not allowed to do? Tell us what those things are. Trying to obscure that is not going to help you. And then you got the state coming out here spitting facts. He done this. He did that. He did that. He's still doing this. And you ignored all of those facts other than, oh, he has a Sixth Amendment right to talk to witnesses, not grand jury witnesses. And your attorney definitely can't talk to them when they're represented by an attorney. So not only is Diddy breaking rules, the attorneys is breaking rules too, allegedly. Come on, y'all. They got to do better. They absolutely have to do better. Like I said, state did a substantially better job. We're only on page 4 of 13. They're going to keep spitting fire at Diddy. And Diddy is not going to be able to overcome this. These are the papers going to the judge. I don't think they get another chance verbally and orally in front of the judge before they make a decision. And that's the paper you want to submit as the defense counsel? The state ate them up. For lack of a better term, the state ate them up. We're still going with the eating, okay? While in pretrial detention at MDC, the defendant has used multiple unauthorized means of communication. This is the question the court asked. Did Diddy answer this question? No, he didn't. What are the unauthorized means of communication he's been using? Which makes it he's used unauthorized means of communication, which makes it difficult or impossible to monitor the defendant's communication. While the government's substantial investigative efforts have identified some accounts that the defendant is improperly using, and the government has obtained and produced those communications, the government has no way of knowing whether there are other PAC or Contact Me ASAP accounts that the defendant is using, of which the government is not aware. So he's already broke the rule. We don't even know if we got all the breaking of the rule of Diddy, is what they are communicating to the court. Put simply, when the defendant uses other inmates' accounts, his communications are very difficult, if not impossible, for BOP and the government to track and monitor. Such barriers to monitor the defendants have real significant consequences, given defendants' extensive effort to taint the jury pool from the MDC, even in the communication the government has been able to identify. We have no way of knowing if this is the only tainting Diddy has done, because we're still searching, because he's using so many people's phone numbers, which he's not allowed to do. And Diddy's excuse last week for why he was doing that, when he wasn't allowed to do it, because everyone else in jail does it. It's common practice for inmates to break rules, and Diddy's just one of them. He's just like the others. He's just like Jefferies and just like Trump. Literally no reason why he's breaking the rules. Now, what would have been a better position, Diddy, is if he didn't follow the common practice within jail. He didn't pay people's books, allegedly. He didn't send people electronic transfers, allegedly. You know, if you didn't break the rules, you would have a slight better chance of getting out. But the fact that you're breaking rules and you're just saying, oh, it's no biggie because everyone does it. What did we say last stream? If your friends is jumping off a bridge, Diddy, are you going to jump off a bridge too? Whose mom has asked them that question? Your mom had to ask y'all that question. Diddy, your mom didn't ask you that question? You going to be a follower is the question. That's the root of where we're trying to get here. Because everyone else is doing it, you think it's okay to do it. I don't think so. I think not, Mr. Diddy. Okay. Let's get back into more stuff. We're not even done. The state is eating him up. Even after defense counsel represented that defendant had stopped using the Contact Me ASAP, he has continued to use Contact Me ASAP account of at least one other inmate, sending messages to family members as recently as November 24, 2024. And they quote, the defense counsel said, with respect to Contact Me ASAP, he stopped using it November 16th. Well, on November 24th, he was using somebody else's. You can't say, court, I'm a good boy, I don't do this. And then you still continue to violate the rules that were already pointed out to you last week. And again, I don't think the argument was that he couldn't use Contact Me ASAP. The argument was that he was using it to contact people that were not on his approved contact list, and apparently using it on other people's devices, which you're not supposed to do. But somehow he wants the court and the state and the government and us to believe that he's going to follow rules in his mansion, his $50 million mansion. He's going to follow all the rules. The one where he allegedly had all these freak offs and parties, right? While at the MDC, it goes on, the defendant has instructed family members and third parties to contact multiple potential victims and witnesses. Diddy thinks this is protected by his right to counsel and right to defend in his case. Sixth Amendment, right? The defendant has provided these instructions to others by using unauthorized means of communication, which, as described above, are difficult to monitor and often using coded language. The potential victims and witnesses that defendant has instructed others to contact include former romantic partners and former employees, most of whom have experienced or witnessed the defendants perpetrate significant violence. At the November 2024 hearing, defense counsel argued that these contacts went through attorneys. However, so the attorneys are defending him. Yeah, he contacted witnesses, but they went through the attorneys. Don't lie. Don't lie. The government's always going to catch you. For example, the defendant asked a family member to call victim 2 while in jail. You're still trying to convince victim 2 of their story, allegedly. Separately, the defendant had a family member three-way dial a co-conspirator, and the defendant and co-conspirator used coded language, discussed a certain, I think, victim who now has an attorney and blank. We don't know what else they said. There was no indication that attorneys were involved in the contacts between the victims, witnesses, and the third party. Because why not call your attorney on the protected line and tell them to contact that witness? And then we wouldn't know all of your business here if you follow the freaking rules. While at the MDC, the defendant orchestrated a social media campaign around his birthday for the express purpose of influencing the jury in the criminal case. In the multiple calls leading up to the birthday post, all of which occurred on unauthorized communication channels, right? Because he has a line that he can call and he gets 15 minutes of and they can one call per hour, but he's using other people's calls. So basically he can be on the phone all day, every day. My guy has to hear his voice, allegedly. He can't sit in silence, allegedly. He can't make friends in jail, allegedly. Okay? In the multiple calls leading up to the birthday post, all of which was on unauthorized communication channels, the defendant meticulously planned out the post. The video depicting 6 of the defendant's children singing him happy birthday while speaking to the defendant by phone was initially posted to the defendant's children pages, but the defendant was not satisfied that it would reach the correct demographic. The defendant told a family member that he had been tracking the analytics from jail. How do you have access to the analytics? And they directed the family member to post the video on his own personal page. And I believe that family member is his son, because there's articles coming out saying that his son took over his Instagram page. But don't quote me, because those are rumors. And it hasn't been confirmed in court documents. So, yeah, there's that. Okay. So they posted it on his direct personal page because the defendant's social media followers are blank. What did he say about his social media followers? I would like to know. In other calls the same day, the defendant talked about the reach of his social media posts and said blank and a question mark. We don't know what he said. Okay. District courts have detained pretrial defendants on obstruction grounds on less, finding defendants engaged in obstructive conduct warranting pretrial detention when a message posted on the defendant's social media account accused prosecutors of bias. The defendants encouraged followers to harass victims in a case, and the defendant previously used burner phones to conceal communications with co-conspirators. That is in United States versus D. Graves. So they are citing a 2021 case in which this applies to, because, social media is pretty close. So out of those things that the other party in that case did, Diddy is doing something similar, right? So they are accusing, or they were engaged in obstructive conduct by posting on social media claiming that the prosecutors are biased. Diddy claimed that they're racist, right? As far as encouraging victims to harass, or encouraging followers to harass victims, I have not seen that. So he's not doing that, allegedly. And defendant previously used burner phones to conceal communications with co-conspirators. What is Diddy doing? He's using other people's phone lines to call people and talk to co-conspirators, allegedly, when we get to that point. Okay, finding the risk of future obstructive behavior identified and articulable. When defendant deleted messages, asked others to delete messages, and began communicating via encrypted messaging application. What did he do? He deleted a lot of text messages to hide his communication with a grand jury person and victim 2. On November 22nd, 2024 hearing, the defendant attempted to distinguish his own obstructive conduct from more violent examples of witness tampering. These distinctions are unavailing. The defendant is charged with leading and founding a racketeering enterprise that on numerous occasions committed acts of violence, including trafficking, kidnapping, and arson. Some of these acts were done by the defendant and others were done by his intermediaries acting at his discretion. What is he doing in jail? He's directing his intermediaries to do things, right? And they're doing it. They're doing it. But somehow he thinks they're going to be able to properly limit them when he's outside of jail in his mansion. Mind you, in his mansion. Okay. Some of these acts were done by the defendant and others were done by intermediaries acting at his direction. Any obstruction or tampering by the defendant must be viewed through the lens of the underlying violent conduct, as well as the lens of defendant's enormous influence and power. Moreover, the Second Circuit has explicitly noted that both violent and non-violent witness tampering supports detention on the basis of potential obstruction. And honestly, based on the allegations against Diddy, does it have to be physical intimidation versus him convincing you with his words? I don't think we need physical intimidation the way that Diddy is running the jail. And this is all my opinion, y'all. But I don't think we need physical intimidation with Diddy. Likewise, other courts in the district have rejected arguments like those advanced by the defendant relating to public relations strategies built on discrediting witnesses and properly influenced prospective jurors. In the context of bail revocation, Judge Kaplan found that a similar pattern of obstructive conduct warranted detention in the Samuel Bankman-Fried case. So that was that the NFT or which one was that? I think that was one of those little crypto cases. That case is instructive. Because, unlike here, the defendant was charged with a nonviolent crime, specifically perpetrating a multi-billion-dollar fraud related to his operation of cryptocurrency company that he founded and controlled, and was initially released on a $250 million personal recognized bond. So $250 million, and he was only committing fraud. Not that fraud is good, but it's not violent. Diddy is offering a measly $50 million while living in the $50 million bond security. Fucking burn down the house and flee the country. Oh, yeah. Okay. However, after the defendant reached out to a witness on an encrypted messaging service, used a VPN, which prevented the government or pretrial services from obtaining evidence of the websites he accessed, and funneled diary entries of a key co-operator to the press, the government moved to revoke bail. The court agreed with the government on the basis that defendant's obstruction, finding that no condition or combination of condition would assure the safety of the community and consequences of witness tampering. I agree. I think that supports the state's position. With that money, with the fact that he's already been eluding monitoring by using other people's phone numbers, right? I think that he is in a similar position. The court rejected the defendant's alternative proposal, a gag on the communication with the press. He already violated that, finding that it was not a workable solution longer term, particularly with someone who has shown a willingness and desire to risk crossing the line in an effort to get right up to it, no matter where the line is. That is Diddy, in my opinion. Finally, it cannot be ignored that the defendant's proclivity, this was good. The defendant's proclivity for obstruction appears to have continued as recently as last week in court. What did we talk about last week? The legal on the notepads. When it appeared that defendants provided falsified documents to the court during a hearing convened to address his accusations of the government misconduct. At the November 19, 2024 conference, defense counsel represented the following about the condition of defendants' legal notepads prior to the notepads being photographed during the MDC sweep. On top of the legal pad, he's handwritten a blue handwriting the word legal. All these legal pads say legal. Remember, in the letter, it did not say that. It said it was on a folder that said legal, and all the documents were under it. All the pads were under it. But then in court, he said, look at this, Your Honor. It says legal on here. They knew it was legal. And again, writing legal on a document, writing attorney-client work product, writing work product, attorney-client privilege, anything on a document does not make everything on that document attorney-client privilege. Now, it puts you on notice that you may be looking at something that is attorney-client privilege, but it doesn't mean that everything on the document is. Either way it goes, Diddy wrote legal on a folder that he put on top of the legal pad, but when they got into court, all of a sudden the legal pad had the word legal on it, and the judge was like, that's a bit suspicious. Why is that not on the actual picture that was taken by MDC? Court, I didn't know that the defense answered to this, and they did answer to it. Let's see. This is what the defense said in court. That page was in a legal pad, and at the top of the legal pad, it was marked legal. Days later, in a response to the court's order dated November 20, 2022, defense counsel admitted that the word legal was written on the notepad after the notepads were photographed during the MDC sweep. So you're falsifying documents. You're saying it said legal, but it didn't say legal at the time that the photos were taken. Now there is a photo of a legal pad that was in the materials with that the government gave us, whatever it was earlier this week, that does not have legal on it. So it has to be the case that as of the day of the search, November 1st of this year, that legal wasn't written on every legal pad. So the defense had to admit to the lie, to the falsified document. Diddy didn't even try to lie and say, no, it was there. The government must have did something to blank it out. He didn't even try to lie. He was just like, yeah, he must have wrote it. It wasn't there at first. I don't know who wrote it. He doesn't blame it on his client, which I guess is good. But I mean, I think we can all draw the inference that Diddy wrote that. I think we can all draw that inference. They go on to say, the inference is clear. After the BLP sweep, the defendant wrote legal on top of at least one legal pad to support his argument that the materials in the legal pad were privileged. This continued obstruction, while he had a pending bail motion no less, should certainly be viewed in the context of all the defendant's other acts of obstruction for the purpose of bail determination. Now, the more I read into the states ripping Diddy apart, okay, the more I read into it, the allegations against Diddy makes him look so bad. It's almost like, based on the allegations, he believes he is above the law. The stuff that all of the civil lawsuits has been alleging against him. He believes he's above the law. He believes he's above the law. He believes he's above the law. Based on all of this, right? What he did before he got arrested, allegedly. What he did after he got arrested, allegedly. What he did while in jail, allegedly. What he did in a hearing in front of the court. The inference that we're drawing. He believes he is above the law. And if you're going to lie to the judge straight to their face, and you're going to employ your attorneys to lie to the judge in front of their face, and you want the judge to believe you should be released on bail in your mansion, okay, that's on the water with all the yachts next door, you got to be out of your mind. The court would be absolutely out of their mind if they release him on bail. If the court releases Diddy on bail, I might stop covering the case, because there's no hope. There's no hope if Diddy is released on bail. Because all of these allegations support the fact that he's going to be a menace out on bail. Witnesses, in my opinion, might come up with missing. Can we be surprised? They better not release him. I'll be very, 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 very disappointed if they release him. Okay, let's jump into Diddy's dangerousness. While there is ample evidence based on defendant's obstruction alone to deny defendant's motion for bail, the defendant's conduct in this case must also be viewed in context of his overall dangerousness. In contrast to many of the cases cited above, there is a statutory presumption in favor of detention, given the defendant here is charged with sex trafficking, and it is thus presumed that no condition or combination of conditions will reasonably assure the appearance of the person and the safety of the community. In addition, the defendant is also charged with participating in racketeering conspiracy as the leader of a violent enterprise that exists to protect his reputation and carry on his will. The enterprise enabled him and assisted him in carrying out both premeditated and spontaneous acts of violence against victims, including kidnapping, assault, arson, and sexual violence. The defendant and other enterprise members carried out brandished firearms, including when the defendant kidnapped a former employee at gunpoint. Like, what? It just gets worse. Over the years, the defendant's physical and sexual abuse has taken many forms, often in the context of long-term romantic partnerships. Throughout, there was a common theme. The defendant repeatedly and consistently forced and coerced women to satisfy his sexual desires. Often behind closed doors, the defendant, which he's trying to be behind his Miami mansion closed doors, where a lot of these incidents already happened. Let me see. The defendant engaged in acts of violence against women, including throwing them to the ground, dragging them by their hair, kicking, shoving, punching, and slapping them. He manipulated, coerced, and extorted women, including by plying them with drugs, threatening to withhold financial support, and threatening to disseminate sex tapes that the defendant had made of their sexual encounters. He intimidated witnesses, including by displaying firearms, threatening them, showing up at their homes unannounced, and attempting to beat down the door on one occasion with a hammer. Beyond his romantic partners, the defendant also physically abused his personal staff. Former staff members have described the defendant threatening to kill them, throwing objects at them, and being struck, punched, shoved by the defendant, and seeing him do the same to others. He basically has a significant history of violence, and the state has showed that by clear and convincing evidence, according to the state. The defendants kind of violate criminal rule 23.1 in the court's order. So the gag order basically incorporated this local criminal rule that the parties are prohibited from releasing from releasing or authorizing the release of non-public information or opinion which a reasonable person would expect to be disseminated by means of public communication in connection with pending or imminent criminal litigation, which they are associated with if there is a substantial likelihood that such dissemination will interfere with a fair trial and otherwise prejudice the due administration of justice. The local rule lists several examples that presumptively involve a substantial likelihood that their public dissemination will interfere with a fair trial and otherwise prejudice the due administration of justice. The character or reputation of the accused is one of those things, and any statement regarding information that is likely to be inadmissible at trial and would, if disclosed, create a substantial likelihood of prejudicing an impartial trial. The defendant's social media posts violate this rule. Remember, his social media post is basically saying that he is a good person. On December, they posted that picture. Let me see if it says what it says. No, it doesn't say. They just say his intent was to interfere with the jury pool. Basically, that he wanted to reach more people by posting it on his own page. We kind of already went over what they posted. The limitation on prospective statements by the defendant. They go on to say the rule. We're not going to go through that, though. We're not going to go through that one. Because we got more to get through. Is basically follow the rule for statements that he would be able to say. They're pretty generic. So he would be able to talk about the identity test, or he wouldn't be able to talk about the identity, testimony, or credibility of prospective witnesses. He wouldn't be able to give information that is likely to be inadmissible at trial and would be disclosed to create a substantial likelihood of prejudicing an impartial trial, which is already in place, and information regarding the character or reputation of the accused. Remember him saying he's a good person and that the government is basically doing him wrong. Nevertheless, the defendant is permitted under Local Rule 23.1 in the court's order to make statements that presumptively do not involve a substantial likelihood that their public dissemination will interfere with a fair trial and otherwise prejudice the due administration of justice. And by going out and saying that the prosecution is racist, he's trying to rage bait us Black folks who, if we must be reminded, he's had a problem with promoting to the Black people with Ciroc. He doesn't want it to be a Black brand. He doesn't want it to be a Black brand, but he wants to rage bait us into believing that the prosecution is only bringing these charges against him because he is Black. And they are racially motivated in politics. Sir, you got about 30 lawsuits, if not more, out about you about beating up women. And if you don't, even if you don't count all the ones with Busby, okay, because he filed 20 million of them, right? You're still almost at 30. So I don't think that they're bringing this against you because you're Black. I think they're bringing it against you because you commit crimes. Yeah. So there's that. There's that part of it. And you think things that you do wrong in jail is protected by First Amendment and Sixth Amendment. Something about that lets me know that you know something that you're doing is wrong. Okay. Let's go on. More. Okay. The defendant attempts to interfere with his criminal proceedings are not protected by First Amendment. Finally, the court also asked the parties to address the defendant, request that, the defendant's First Amendment arguments related to the gag order that the defendant requested and that was entered on his consent. Again, he requested the gag order. He knew that it involved his statements as well. He consented to the order. And now he's saying that the order inappropriately interferes with his First Amendment rights. You consented to it. What do you want them to do? In short, the First Amendment does not protect his efforts to interfere with his trial or prohibit the application of the order of his statements. It is well established that criminal defendants do not have unlimited rights to speak. In the context of an ongoing criminal case, a party's First Amendment interest may be outweighed by the constitutional right to a fair trial, permitting a court to prescribe prejudicial, extrajudicial statements. Noting that a few, if any, interests under the Constitution are more fundamental than the right to a fair trial by impartial jurors, and an outcome affected by the extrajudicial statements will violate the fundamental right. So the right to a fair trial is more important to your right to freedom of speech, is basically the laws that the state is citing. Accordingly, the courts have on numerous occasions in cases involving substantial pretrial publicity upheld or imposed restriction on defendant speech aimed at influencing witnesses' testimony either directly or indirectly. Also citing the Trump case. The defendant's extrajudicial communication in this case are not, as he alleged, classic protected speech. Instead, the defendant explicit attempts, for example, blank, we don't know what he said, constitute improper efforts to interfere with the integrity of the proceedings with the court, which the courts are obligated to protect against. The defendant nevertheless claims that these types of communications are constitutionally protected because they merely represent the defendant's thoughts that his prosecution is politically motivated or that he is innocent of the charges against him and constitute protected speech. This is untrue. They are part and parcel of defendant's repeated attempts to clear contempt of the court's order and in violation of the local rule, to use his family and associates to make public statements to obstruct and subvert the integrity of these proceedings. There is nothing constitutionally protected about such speech, and the court does not have to wait to intervene until the defendant has been successful in impacting the proceedings. They go on to talk about the Trump case. And finally, to wiggle out from underneath the gag order that he demanded from this court and consented to be bound by. The defendant now claims that the First Amendment permits him to continue to engage in the communications that may prejudice these proceedings as long as the potential juries are subject to voir dire and he is prevented from speaking directly to witnesses. But the Supreme Court has made clear that the court must take remedial measures that will prevent the prejudice at its inception, not wait until the prejudice may have already materialized at the time of voir dire. Because if you do that, you might go to voir dire and then you get no freaking witnesses because everyone has already heard this nonsense that Diddy is putting out. So state saying, no, you're not protected by the First Amendment to basically taint the jury pool, which he admits to doing. He's claiming that he's just trying to clear his name, but you consented to this gag order. You asked for the gag order, and actually he asked for a more restrictive gag order than the one that was put in place. He also didn't want people from the other cases talking about him, right? He wanted a super restrictive gag order, and now that it's being applied against him, he's like, oh no, I don't want that one no more. I don't like that one no more. Can we change it for me only though? I don't want the prosecution to talk about me. It's like an entitled child. I don't want them to talk about me, but I don't talk about them. And they should be able to take you because they're the government. Like, what are we talking about, Diddy? What are we talking about? The conditions posed by the defendant failed to ensure the safety of the community. For all reasons stated herein, there are no conditions sufficient to reasonably ensure the safety of the community or defendant's appearance in court. But to the point about which the court inquired of the government on November 22nd, 2024, the government additionally writes to make clear that the package proposed by the defendant is insufficient on numerous respects. Without any meaningful specifics, the defendant argues that through private security, he can turn an apartment in the Upper East Side of Manhattan into a more restrictive environment than the MDC, than the jail. He thinks he can make a jail in his apartment and meet the requirements of the Bail Reform Act. The proposal relies on a private security company to monitor family visits, ensure zero non-lawyer phone or internet usage, and restrict visitation to a pre-approved list. He already has a pre-approved list for phone calls, and he doesn't follow that in jail. Such a proposal, in essence, elaborately replicates a detention facility without the confidence of the security such a facility instills, citing a case. But as the courts have observed, security guards are not trained to act as jailers or detectives, and a home is not a secure facility. More to the point, in this case, private security employed and paid for by defendant cannot be trusted. Throughout the charged racketeering conspiracy, the defendant has used private security to stash weapons, purchase narcotics, pay commercial sex workers, and tamper with witnesses, among other things. The defendant did so through the racketeering enterprise that he led and controlled, and through which he wields his immense power and influence to cause others to act on his behalf. Private security paid for by the defendant cannot ensure that the defendant will not access contraband communication devices or tamper with witnesses, because the defendant has done just that while incarcerated. And he turns around and tells you that he's protected to do that under the Sixth Amendment. Yeah, don't forget about that part. He can do that. He's allowed to do that, according to Diddy. Further, under the proposed conditions, the defendant would still have access to individuals such as family members who could act as his intermediaries as they do now, smuggle in contraband devices to him, or even bring him drugs. It is simply unreasonable to pretend, I think they mean pretend, that the defendant would not use whomever he has access to, family, security, even legal staff, to accomplish his aims. He even got the legal staff on rap right now. No amount of private monitoring can effectively mitigate this risk. The proposed conditions also fall short of significantly protecting against future violence and obstruction. Defense counsel claims there is 0% chance that defendants would be violent towards someone while out on bail under the proposed conditions. He don't even follow the rules in jail. This gross overstatement ignores the reality of defendant's history, including acts of violence he carried out himself and through those working on his behalf. Unless private security can staunch the defendant's malignant influence over everyone around him, a pattern that has resulted in numerous individuals being physically harmed and threatened for decades, the court cannot have any confidence that the community will be safe with the defendant out on bail, regardless of the presence of private security. Likewise, private security will be ineffectual at preventing the defendant from violating his conditions. The defendant has decades of practice at covering up his crimes and shows no signs of stopping. Yeah, he's still doing it in jail. This is in addition to all of the other rules set by BOP, the court, and even his own counsel that the defendant has broken and ignored since the recent inception of his criminal case. That is true. A promise now that he will abide by the conditions of release is insufficient. Also citing a case, you've been violating the rules this entire time, and now all of a sudden you want us to believe that you're going to do right by us? Yeah, no thank you, Diddy. Finally, the defendant's lawyer and family members do not provide meaningful guardrails to the defendant's conduct, insufficient to ensure the safety of the community, and that the pretrial detention was a means chosen by the Congress in Bail Reform Act. Far from assuring that the defendant will abide by conditions, these parties have enabled the defendant to flout rules while at the MDC. Moreover, defense counsel blasé attitudes towards breaking these rules while simultaneously asking this court to release their client does not give the government any confidence that counsel will be able to police the defendant's conduct with any rigor. They haven't. So far, they haven't. Indeed, contrary to the representations by counsel just days ago, the defendant has continued to engage in unauthorized communication with family members from the MDC by using another inmate's Contact Me ASAP account as recently as yesterday. I think that was an amazing point to close on. He's still not following the rules, even after coming in court, lying to the court for one, lying to the court presenting false evidence, telling the court that he's no longer breaking the rules, just to turn around and break the rules 3 days later? He can't even survive 3 days. Y'all think he gonna be sitting in that house not talking to no one? He haven't even been able to sit in jail and not talk to anyone for an hour. He's permitted 15 minutes every hour. And he couldn't even do that. And you want to tell me he not going to have no phone? He not going to have no visitors? He ain't going to contact people that he not supposed to contact, but he's doing that while in jail? How are we supposed to believe this? And like I said, I just don't see, with everything that the state puts out, and I have to rely on what the state is putting out because the defense didn't put out anything. The defense didn't explain how he didn't violate rules. The defense didn't justify him violating rules. He just said, I'm allowed to do it. So when he gets out, he's going to be allowed to do it. He's going to do whatever he wants, like he's been doing in jail. Let him keep doing what he wants in jail. The thing about if he gets out of jail, he'll be able to do it with less restriction because the state has been able to keep up with what he's doing. The U.S. has been able to keep up with what he's doing. He doesn't want that. He thought that using other people's numbers, they wouldn't be able to find him. They found you, Diddy. They found you. And word on the street, you can't sit in silence. Because you're using everybody's phone to talk. Yeah. So Diddy, I don't know what you're gonna do. I don't think that Diddy should get out. Y'all let me know in the chat if y'all think Diddy should get out. I don't think he should. I think that the judge will be out of their mind to let him out with that weak letter that they presented, false evidence being displayed in court the week prior, multiple violations of the BOP rules, and expecting for him to follow rules while out on bond. There's just no avenue that I can see the court going under clear and convincing to let him out. It's not clear and it's not convincing that he's not going to violate these rules. He's already breaking rules. He can't say I'm a good boy now. He said he was a good boy now last week. And what did he do? He broke the rules. He didn't even object to that or try to contradict that. I'm a good boy, judge. And then on Sunday, 3 days later, you're violating the rules again. You're not a good boy. I don't know why I'm calling him a good boy. But anyways, let me know what y'all think in the chat. Make sure y'all are hitting the like button. We are live. We're at 19 likes. We got 23 people watching live. So if you haven't hit the like button, please do. We are trying to hit a like goal of 30 likes this live stream. If you're on the replay, of course, make sure you're also hitting the like button and leaving your comments of what you think about the case. Let's have Bossy B bring us into the chat. Uh-oh, I forgot the button. Let me know what y'all think. Let me know what y'all think. And then we'll get up to updates for the next coming weeks on the channel. Crystal Harris says, live in the hive. Hello and welcome in. Welcome in. We got Erica saying, what happened with the notepad having a word that wasn't there before? They actually addressed it in the state's letter. The defense had to come out and admit that it was not there when it was taken. Essentially admitting that Diddy or someone at the direction of Diddy wrote that on the notepad and brought that into the courtroom, presumably. That's essentially what they're admitting. It wasn't there after the picture or before the picture was taken, is what the attorney told to the judge, according to the state's documents. Diddy said, is Jefferies a billionaire too? I believe he's a millionaire, but don't quote me on that. Capricorn 11 says, hey everyone, hello and welcome in. We got Deacon Fatal saying, good evening, Boss Bree in chat. Hello and welcome back. Member moderator of the channel, Deacon Fatal, also dropping $10 super chat. Thank you very much. Sam Mustard. I can't do that noise. I got 96 on my class, and don't mind me. They are talking out the side of their butts. Yes. Thank you for the super chat and congratulations on passing your test. What are you, girl? You about to be. What are you? I forgot. What are you getting? A master's? I can't remember. Let me know. I think she also already dipped out, so I don't know. Deacon Fiddle says discovery is a thing. It is a thing. Wait, what? Deacon Fidel says, okay, there are a lot of victims. There are a lot of victims. That is witness tampering, but he thinks it's protected by the Sixth Amendment right. Don't know how. He thinks that he should be able to reach out to witnesses on his own, which normally you can when they're like your witnesses, not the government's grand jury witness. You might want to have your attorney do it, and you might want to have your attorney reach out directly to their attorney when they're represented, because they're represented by an attorney. So yeah, I don't know what his thought process is here, because he has to be in charge. He is in charge. He has to influence them and get them to say what they want. Especially when everything you do has been considered to be obstruction and tampering, you might want to try to go through your attorneys next time. Okay. Deacon Fatal says, listen, I woke up to this butterball turkey thing. My bandwidth stopped there. Deacon Fatal says he does need to stay in jail. I agree. Deacon Fatal says to me, can the governor overrule any of this? Not the governor, no. So he is in jail. The only person that can let him out of jail is a judge. The only person that can let him out of the judge, or the only person that can handle the appeal is another judge. No, the government cannot let him out. Or sorry, the governor cannot let him out. Deacon Fiddle says, oh, he is definitely a flight risk. For sure. For sure. He lives on a freaking bay with a bunch of yachts next to him. He's going to leave. And see, he still has his plane. Sell that thing on discount. Stop trying to make a profit off your plane, bro. Deacon Fiddle said that's not how that works. And he's been doing everything he could. Deacon Fiddle says he has to know that all jail calls are recorded. The thing is, he's trying to circumvent his recorded jail calls by using other people's numbers. So the calls are not associated to his name. They're complicated, kind of. I don't think it will work exactly. Deacon Fiddle says Mr. Combs is what I will refer his name as, such as Defendant Combs. Does he deserve to be Diddy anymore? He left a digital trail. Of course, everything leaves a digital trail. Any electronic device leaves a digital trail. Deacon Fiddle says, if that was true, could the lawyer lose their license for communicating with lawyers and witnesses? They can communicate with the lawyers directly. They cannot communicate with a represented party. So the witness, the grand jury witness, allegedly, according to the state, was represented by counsel in this case. So in order for Diddy's attorneys to talk to that witness, they would need to they would need to speak directly to their attorney and get permission. If they want to speak to them directly, they can, but they have to get permission from that witness's attorney. Just Stacy says, hi, everyone. Hello. Welcome in. Deacon Fiddle says, I can see the witness intimidation being a thing. Yeah, especially coming directly from Diddy. Like, I feel like we don't need the violence he was referencing. Oh, I'm not that bad because it's not violent intimidation. I'm just intimidating them a little bit. Deacon Fiddle says there has been video of people following this case that have been stalked and questioned by Defendant Combs' private investigators. I heard that too. No one's asked me any questions. My channel, I think, is too small. Just Stacy says, but crypto was financial crime, not physical attacks. Yes, exactly. And that's what the the government pointed out. Deacon Fiddle says, oh, he will run. For sure, he will run. Just Stacy says, I think he will run too. That is my opinion. You let him out, we not seeing Diddy. He gonna be living in Colombia with a whole new identity, bro. Like, we are not getting Diddy back if y'all let him out. Deacon Fiddle says, I forgot about the notepad thing. Yeah, so they did get some, I can't think of any words today. They did get some finality to that. The defense had to admit that it was placed there after the pictures were taken, which is pretty embarrassing, right? You're putting your license on the line for this lying dude, okay? Just Stacy says, that is adding to not playing by the rules for me. Yes, you can't even follow the rules when in jail. Like, he would have had a so much better chance if he would have just followed the rules while in jail. I would have been a little bit more skeptical of, oh, he's been on the prim and proper. The, state hasn't found anything that he's doing wrong. I would be more like that if he was following the rules in jail. But not only is he breaking the rules in jail, he wants to then be released and say, "Oh, well, I'm not going to break the rules in my own house." Bro, you make the rules in your house. What are you talking about? You're for sure going to break the rules. No, you won't break the rules because they're your rules. Deacon Fatal's the member for 29 months. Shout out to Deacon Fatal. Says, so he pulled the Brooks thingy, tired still, glad I'm a member. Oh, no problem. Thank you again for being a member for 29 months and supporting the channel. And Deacon Fatal has like gifted memberships to people. And as you see, giving super chats to me. I definitely appreciate it. We appreciate you on the channel. Deacon Fatal says he has a lack of control. And what would be cool if you and Dr. Barry get together and talk about this case? I'm not familiar with Dr. Barry, but he does have a lack of control. To me, based on what the state presents and what defendants' documents has presented, in my opinion, he's a bit childish. If he doesn't get his way, it's a tantrum. It's, I didn't do anything wrong. You're the problem. That's a problem. That's going to be a problem for him in trial. And I hope he does not testify for himself. But if they let him out on bail, he's gone. So there will be no testifying. Deacon Fatal said, it is plausible and that is unfortunate. Deacon Fatal said, it's always about control. Erica says, did he not realize they'd figure this out? Like, it's not even hard to figure out what he's doing. Yes. It's like, we're already on to you. Last week, the state let you know they were already on to you. And what do? You just redo the same thing. Like, you don't even care about being caught. Or you just think you're that good that this time you know you're going to be able to obstruct, which you're doing a little bit better this time. That has to be it. They keep pointing out that, oh, he didn't know he couldn't use the Contact Me ASAP. I don't think anyone ever said he couldn't use Contact Me ASAP. They said the way he's using it is impermissible, i.e. using it through other people's number, i.e. saying he's texting his son, but he's really texting Bob Joe Quo down the street. That's the problem. Not that he can't use the messaging app. It's the way he's using it. And they're just skipping over that. They're like, oh, no, that can't be the argument. Like, are y'all not reading the papers or am I not reading them? Maybe it's me. Maybe I'm not reading them. Just Stacy says, I think it's more he doesn't care if they know. That could be it too. Above the law. Above the law. Deacon Fiddle says, all right, since I'm sleepy, Combs knew he wasn't he wasn't a good artist and he was jealous over everyone around him that was. KP says, Diddy's entire attitude in life screams, I believe the rules don't apply to me and I can do whatever I want. After today, like we've been covering this for the last week. After today, I completely agree with that. The rules does not apply to Diddy in his head, in my opinion. Deacon Fatal says, peep this. He gives me the same energy as Charles Mason. I don't know much about him. Then he says, the audacity, how is he trying to play the race card? Yeah, that's his big argument. The prosecution's racist. Sir, you are being accused of raping minors. R-word and minors, sorry, YouTube. I don't think it's because you're black. I just don't. I don't think that's the reason. And not even talk about minors. Cassie was barely legal when you got with her, and he was almost 40. So I don't think it's because you're black. I think it's because the things you're doing are bad. Deacon Fiddle says, I might end up writing a paper about this guy in school. I can compare him to many serial offenders. Yeah. Yes. You can. Deacon Fiddle says, have you have to head to bed? Yeah, this guy is really messed up and should stay in jail until the trial is finished, in my opinion. I think he should stay in jail after trial because he needs to be convicted. Erica says, I wish it was a woman judge and prosecutor. I don't know if it will make a difference. I think is the judge not a I don't know. I think it is a guy now. But I don't think that's going to play a role in it. I think the judge is going to uphold the law. I'm fingers crossed the judge is going to uphold the law. There's like, I can't see a path that a judge can justify letting him out. Unless it's just like, okay, we'll let him out so that he won't appeal and then he'll be right back here in a week because he's going to violate his rule. Immediately, he's going to violate those rules. It's going to be harder to catch it because then he'll be out on bail. I think leaving him on jail is the best route. Deacon Fatal says, yes, a child. Deacon Fatal says, night, night. Aw, thank you, Deacon Fatal, for joining in the live stream, the super chats, and being a member for 29 months. I hope you have a good night. Just Stacy says, good night, Deacon Fatal. Denny says, there's no way they can let him out. He's dangerous. And he breaks all the rules. He's breaking the rules in jail. He's breaking the rules in jail. Just Stacy says he's reckless and will be worse if released. Oh, he's going to feel like he's way above the law if they release him. Way, way above the law if you release him. That's going to be really dangerous. David says Trump is not a PDF file. I don't know what. Oh, are you saying because he's comparing himself to Trump? Doodle Noise, hello, member of the channel, saying hi, dropping a sunflower bremoji is what we can call it. Welcome in, nice to have you in tonight. We got Kobe56 saying, who are you? No one, just a girl on YouTube. I'm no one. KP says, I think after the legal pad debacle, the judge won't be so open to hearing anything from the defense, what the defense has to say about bail now. I think that they were done. Honestly, their letter answering the specific questions of the judge and that it didn't answer the specific questions of the judge, I wouldn't consider anything they had to say. You didn't even you just cited a bunch of cases. You didn't tie it to the facts of the case. I'm confused and I'm legally trained. So I think that the judge will be confused with that brief that was written. It almost seems thrown together. I know it was the weekend. You had a lot of time to prepare this. And apparently you're going to babysit Diddy if he's out on bail. So you should have had plenty of time to prepare a wonderful answer. I think the issue is that you don't have an answer. There is no answer. He violated rules. He broke rules. He's trying to use constitutional rights to justify his behavior, and it just doesn't apply here. So like I said, I do think that he'll end up firing his defense attorney, because he's going to feel like they're not fighting and they're losing and they don't know what they're doing. But really, it's, bro, you're setting us up for failure. You're making the facts of your case bad to the point where the defense attorney couldn't even tie together what behavior has he been. They're not going to tell on him and say, yes, he's been doing this behavior. He's already admitted to the behavior. They're not going to reiterate it. So there was literally nothing to do in their document other than to cite case law and not tie it together. But say he should be let out and he should still be able to contact witnesses because he has to prepare his defense. Let your attorneys do it. Do depositions. Do it the proper way. But at this point, defense attorney, I would probably fire him as a client. He is going to make you lose your license, in my opinion. Making you lie or having you lie to the court? Or are you having him do that? That would be my question. Are you permitting him to do that and then lying to the court and saying that you would monitor him? Either way it goes, they all suck. In my opinion, it's either the lawyers are lying or Diddy is lying. Which one do y'all think it is? Lawyer or Diddy lying? Y'all, we made it to 24 likes. If y'all haven't hit the like button, our like goal for the stream was 30 likes. So if you haven't liked the button, please do. It does help us out. And if you're on the replay and you made it this far, make sure you are also hitting the like button. Y'all, that is all that I have for tonight. This upcoming week, of course, is Thanksgiving. So I am probably going to stream tomorrow and then I'll be off of streaming for the rest of the week and probably the next week. I probably won't be back to streaming until next Thursday or Friday because I am going to Hawaii next week for my birthday. Turn up. Yeah. Going to Hawaii next week for my birthday. So I probably won't be streaming. If I can make a stream next week, it'll probably be Thursday or Friday. And I will try. I know I keep saying I'm going to try to do shorts. I need to. I know I need to, but I'm going to try to do some shorts and keep everyone posted. Tomorrow, we are doing food court. If we come out with a decision on the Diddy case, I'll touch on that briefly, but then we're going to do food court because there are some good food cases that have come out that I think that the channel will enjoy, and then I'll probably chop that one up. So anyways, I hope that everyone has a wonderful night, and I hope you enjoyed this Diddy case, this Diddy debacle, and we will see you, or I will see you all on